My name is Chris Moore. I'm a senior solicitor in the clinical negligence team at Hudgell Solicitors. I specialise in handling catastrophic injury claims, and in particular I specialise in birth injury claims. Injuries can be caused to both the mother and the baby, and typically for the mother you may be looking at a mother who has suffered severe perineal tears. They can be caused, for example, by way of inappropriate use of the instruments during birth. Another type of injury which the mother may suffer would be a back injury, which may be caused due to anaesthesia, for example, an inappropriately administered epidural. As regards to children, two of the most common injuries that we deal with are a brachial lap palsy. With those injuries, the child suffers an injury to the nerves within the brachial plexus system. And again, that may or may not be caused by inappropriate obstetric management. The other injury which we often deal with is cerebral palsy. That is a brain injury which can affect a child's movements and posture. It can also affect a child's ability to communicate, and the child's intellect may or may not be impaired. With those injuries, it's not always the case that it's due to medical negligence, but if you're talking about a long and difficult labour, and there's some suggestion that the child has been born in a poor condition requiring resuscitation, for example, then that may be due to negligence and a failure on the part of the hospital to intervene by way of emergency caesarean section. The implications for the baby and the family are enormous. A child who suffers from cerebral palsy may or may not be capable of living an independent life. This will depend on the severity of the brain injury. But in many cases, sadly, they are incapable of living an independent life, and it's necessary to put care packages in place that will last for that child's lifetime. The other thing with cerebral palsy is that invariably life expectancy for the child is not affected. So the care packages will need to go on throughout his or her lifetime, and during the period when sadly the parents will no longer be around to look after the child. So the implications are enormous. In order to prove negligence in medical negligence claims, and a cerebral palsy claim in particular, what we need to do is to obtain the mother's and the child's medical records in the first instance. We then need to obtain appropriate expert evidence, and in a birth injury claim, the first thing we would do would be to obtain independent obstetric and gynecological evidence to assess whether there has been any negligence in the management of that child's birth. Hudgell Solicitors has considerable experience in dealing with all clinical negligence cases, and specifically birth injury claims. We have dealt with many cases over the years and as I say, have considerable experience. In recognition of our experience in this area of the law, we've actually been accredited by the Law Society onto their expert panel of specialist clinical negligence solicitors. We also have been awarded a contract by the Legal Aid Agency to enable us to offer public funding to clients in appropriate cases.